matter to come before the court this morning is State of Ohio versus Nastick. Both sides will have 15 minutes to argue. The state has waived argument, so you may proceed. We have read the briefs and we're ready to go forward.
Thank you, Members. May it please the court, my name is Ben Sorber and I represent the appellate, Mr. Adam Nastick. This case presents two issues for the court to consider. The first is, did the trial court err in denying Mr. Nastick's motion to dismiss based on the state's failure to preserve the video evidence of the stop and arrest of Mr. Nastick? The second issue that this case presents is, did the trial court err in denying Mr. Nastick's motion to suppress based on lack of probable cause for the warrantless arrest? For the purposes of oral argument today, I'm just going to focus on the first of those two issues and rest on my briefing for the second issue. So the first issue involves the exculpatory nature of the video that the state failed to preserve. Dating back to Brady versus Maryland, the United States Supreme Court has held that evidence which is material to either guilt or punishment must be disclosed to a defendant. Following that case, the United States Supreme Court noted in Arizona versus Youngblood that when the state loses or destroys materially exculpatory evidence, the defendant's due process rights have been violated and the good or bad faith on the part of the state is immaterial to that question. In this case, Mr. Nastick's due process rights were violated when the state failed to produce and failed to preserve the video that they created of his traffic stop. And exculpatory evidence is evidence which, if disclosed, would have a reasonable probability that the result of the proceedings would be different. And that's something that the Ohio State Supreme Court held in State versus Johnson. Now, that reasonable probability is a probability which is sufficient to undermine confidence in the outcome. The evidence contained in that video that the state made of Mr. Nastick's stop and arrest was materially exculpatory because it goes to the substance of the charges against him. You see, in this case, Mr. Nastick was charged with improper handling of a firearm in a motor vehicle. He was charged with failure to timely inform the officer that he had a firearm in the vehicle. He was also charged with driving while impaired. The evidence contained in the video went to the substance of all of these charges. The problem with this case was that the stop of Mr. Nastick occurred several months before the officer testified at the hearing. By the time that the officer came to court to testify at the hearing, he admitted that he had little to no independent recollection of the stop itself. Instead, he was forced to rely upon the report that he made, which contained minimal to no details of the stop itself. During the hearing, the officer testified initially that Mr. Nastick failed to inform that there's a firearm in the vehicle, and he only discovered the firearm when he was doing his tow inventory prior to towing the vehicle after Mr. Nastick was arrested. Later in the hearing, after looking at his report some more, the officer changed his story and said Mr. Nastick may have told him something about a firearm sometime within the first 2 minutes of the stop. The fact is the trooper couldn't recall. But the trooper did recall that he was wearing a microphone on his person that day and had video recording in his cruiser. The microphone and the video would have recorded that interaction and would have showed exactly when and how Mr. Nastick informed him that there was a firearm in the vehicle.
Mr. Sorber, I know between those charges, the improper handling would probably not have been as much of a concern to your client as the CCW. Now, I apologize, I don't have that indictment in front of me, but with the improper handling, was that because of the allegation of alcohol, or was it under a different section?
No, it was, Your Honor. My recollection is that it was a felony 5 for the improper handling due to his intoxication.
Felony, it would have had a more significant effect than for your client. How would the fact that the officers skipped the video, that the officers' notes and recollection of, I know this is shocking that a state highway patrolman would say this, but odor of alcoholic beverage about his person, red bloodshot eyes, how would that affect the improper handling?
I don't believe it would, Your Honor. As this court and other courts throughout Ohio have noted, it's not illegal to have an odor of alcohol on your person and operate a vehicle or have a firearm. It's the intoxication or impairment that's focused on. And as you go through the stop itself, as the officer was testifying, he was unable to recall the certain indicators that they're trained to look for when determining if someone was impaired.
So you're saying that the OVI and the improper handling both revolve around impairment?
Correct.
All right, thank you.
Correct. Those two issues would revolve around the impairment, which the officer had little independent recollection of it. And separate of that, which was also captured on the vehicle, on the video rather, was the failure to timely inform or the manner in which he informed. So that's why the video and the microphone recording is so important to all three charges that Mr. Nastick faced in this case. So moving on to the impairment issue, that the officer's recollection of that seemed to break down almost from the beginning of the stop. He couldn't recall whether Mr. Nastick had slurred speech or not, which is something that officers are trained to look for in determining whether someone's impaired. Next, he went on to testify about the field sobriety tests. Without looking at his report, he couldn't recall what clues, if any, Mr. Nastick showed on the walk-in turn. After looking at his report, he indicated there were 4 clues that he saw, but he couldn't describe the nature in which he saw these clues. For example, one of the clues was that Mr. Nastick failed to maintain his balance while listening to the instructions. The officer admitted that some people just shuffle their feet while they're standing and listening to the officer. Others will kind of stumble around. He couldn't remember if Mr. Nastick was someone who just kind of shuffled while listening to instructions, or whether he was really struggling to maintain his balance. The other clue that he said he indicated was failing to touch heel to toe, and at one point he said Mr. Nastick stepped off the line. But again, that was all that was marked on the report. Beyond the report, the officer couldn't recall, and this wasn't indicated in the report, was whether Mr. Nastick's heel to toe failed to touch by less than an inch or several inches. These are important clues that would have gone to whether Mr. Nastick was impaired at all, and the nature and extent of his impairment. Because that goes to the substance of the charge, that's what made the evidence in the video materially exculpatory.
Well, I think the state maintains that because of the lack of any contradictory evidence, that anything related to the video is supposition by the defendant that it's exculpatory. That it might have been beneficial, but how would we know?
Well, the thing is, because Mr. Nastick requested that the state produce the video, the burden shifts to the state in this case to prove that the evidence in that video was not exculpatory. That's not Mr. Nastick's burden to prove. And the state was not able to do that because the testimony propounded by the officer really wasn't able to indicate whether Mr. Nastick was impaired or whether these were just de minimis indications that he was seeing on the standardized field sobriety tests.
But all that information that was observed at the time of the arrest was noted on the report, correct?
The officer had checked boxes on the State Highway Patrol test, but he had no recollection independent of that report itself, which is interesting because the report itself generally is not admissible into evidence at the trial anyway. It's only used to refresh the officer's own recollection. And beyond him being able to testify, I checked the box sways while listening to instructions. He was unable to testify whether it was just a minor sway or whether Mr. Nastick was stumbling to maintain his balance.
So is your argument that the trial court did not follow the correct burden shifting necessary, or that you disagree with the outcome about whether or not the court's finding that it was not materially exculpable was correct?
I believe that if you read the trial court's order, it appears that the trial court did follow the proper burden shifting. They note in there that the burden does shift to the state to prove it was not materially exculpatory in this case. But beyond that, that's when the trial court erred in finding that the state met its burden. Specifically, the trial court relied on 2 cases. I believe it was State versus McLean and State versus Cahill. And those were 2 appellate cases from other jurisdictions where a video was lost and the appellate court found that nonetheless the state was able to meet its burden. But those cases are greatly distinguished from this case. In Cahill, the trooper was able to testify and the court says it in quotes, great detail about the nature of the field sobriety test and the clues that the officer observed. In this case, the trooper was able to testify in no detail, and once he had his report in front of him, was able to give only minimal detail. So that's what is the unique nature of the video in this case. And the evidence in the video, Mr. Nastick cannot obtain through any other source because the trooper's testimony was not sufficient. In State versus McLean, there was a blood alcohol content test where the defendant tested well over the legal limit. We don't have a test like that. There was no portable breath test administered on scene, and Mr. Nastick did not provide a breath sample at the State Highway Patrol. So we're left only with the observations of the officer and what he remembers. Because he was not able to independently recall much, that's why this was exculpatory evidence and the state didn't meet its burden. And that's kind of what distinguishes this case as well from State versus Giesling. That's an Ohio Supreme Court case where only a portion of the video was lost. In that case, the portion of the video that was lost or destroyed was the portion that showed the traffic violation which prompted the trooper to stop the defendant. The actual field sobriety tests themselves and the officer's interactions with the defendant were still preserved on the videotape, which was eventually produced. In that case, the Ohio Supreme Court said that the traffic violation would only have been potentially useful because the defendant could have used it to show there was no traffic violation and thus possibly win a motion to suppress. But the exculpatory, or what would have been exculpatory, the portion of that video was the field sobriety tests. And because those were preserved, the portion that was lost was not materially exculpatory. In this case, the entirety of the stop was lost, including the field sobriety tests. And that's, the Ohio Supreme Court distinguished that from State versus Benson, which was a case where, in that case, the charges were dismissed because the field sobriety tests were recorded on a video, which was then lost. So in this case, because the state failed to preserve that video and failed to meet their burden that showing that either that was not materially exculpatory or that there was an independent source for equal evidence, this case should have been dismissed. So for those reasons, we would ask that this court reverse the trial court and find that they erred in failing to grant Mr. Nastick's motion to